So, good morning, everybody. We wait a couple of seconds to let the other people to connect, and then we start. So, good morning again to everybody. I'm Giulio Poggiaroni from EUBIA, partners of the Biomac project. And today we are at the third webinar of the training activities scheduled by the Biomac project. And today we'll touch upon another different argument, which is intellectual property rights and how to protect them. In the project, we talk about innovation, we develop innovations, we are providing through the open call services for SMEs who want to upscale new ideas and concepts. So IP, intellectual property rights are closely associated with innovations, and sometimes there is limited knowledge on how to protect them. And today's today's webinar is exactly about this. We will discover how intellectual innovation protection could prevent an actual loss in strategic assets, and we will try to show you a practical approach to IP legal tools and how to best handle them. Today's speakers is distinguished speaker is Michele De Giorgi. He's Italian and European patent design and trademark attorney at the European Patent Litigator, qualified for representation before Unified Patent Court. Sorry, I gave the.
Thank you very much, Giulio, for the very long name.
Yeah, it's a very long, but perhaps you can introduce it better, and I give you the floor right away. For the attendees, remember to use the Q&A box to post your questions that will be answered at the end of the presentation of Mr. De Giorgi. So Michele, please, the floor is yours.
Thank you, Mario, very much, Giulio. I will only say that I'm a counsel in IP, so I help and support entities in valorization of their IPR assets. I will start immediately with my presentation and try to share it here. You probably can see it in full screen. Anybody can confirm?
Yeah.
Yeah, okay, perfect. Here we have the summary of the topics of the menu of the day that Giulio already introduced. I want, first of all, to focus on not on what usually we know about intellectual property rights, but on the biases that usually during my professional life, I see that are spread through economics and entities. So we would like to start. I would like to start with one single intellectual, let's say, legal tool that I will use as an example for the other legal tools that will be are available, and we will speak about later. But I won't like to focus on patents, because patents is something that almost everybody has heard about during its life, and on which I think there are strong biases are present, and sometimes those biases leads to an actual loss in strategic intangible assets for enterprises, and in particular for small and medium enterprises. This is why I entitled I put this title on my presentation, The Patents and the Magic of Inventions. First of all, because inventions have something magic and deals with something magic, because something that is not new, is not known, sorry, until the inventor discloses it to the collectivity. So it has some flavor of magic, in my view. This, I think, is an example of magic. Magic, which is actually nothing more than a very smart technical solution to allow attractive show to be performed. In this case, we have a patent in the name of Mr. Michael Jackson. I think you have heard about him sometimes. And this is the solution. Just in the heel, you can see this recess, and you can see also this element put in the floor, so that during the ballot, he could hook the heel in this element, metal element, in order to achieve this magic position. I would like to start, I started with this to make it clear that one thing is, and we shall not mismatch between the invention, which is the magic that is inside which is the content of a patent, for example, and the patent itself, that is a legal tool to protect and to enhance competitiveness. So let's start with another story about patents. The first is, of course, a real story about Mr. Michael Jackson. This one will be fantastic, just in part, only in part, because my story starts with once upon a time, as every story, and lighting pens one is invented. And this story is about a pen which it consists just in a snap-on pen, very normal snap-on pen. The particular feature is that it has a LED housed inside the tip of the pen, so that as soon as it is snapped on, the pen lights up. The end tip of the pen lights up. This, the inventor of the pen, experienced in our story a striking success of this enlightening pen of his product. And also the customer was so excited about this new product that a lot of feedbacks came, and he was compelled to implementing the product, in particular for allowing it to be used for writing in low light condition or in the dark. Mr. Penn, of course, tried to improve his product and find out how to create the enlightening extra. This was the name of the product, where the transparent portion was limited to the very last end of the pen, the tip of the pen, to concentrate the light in the writing area. This effectively allows to write in almost dark condition or very small light conditions. In addition, Mr. Pence, sorry, was testing also methods for increasing, enhancing the effect of lighting by making reflective the internal part of the tip of the pen. This was the result, the new extraordinary enlightening extra pen. Once again, the market enthusiastically reacted to Pens and Pen's new product launch. Therefore, of course, as usually, an ambitious industrial plan was implemented. Large investments were committed to enhance the productivity for meeting the ever increasing market demand. But in the meanwhile, as in any story happens, here comes the evil one. Let's discover it together. Here comes Advertising Pen by Mr. Huang Ming. This was presented triumphantly at the stationery trade fair for the field of stationers, of course, and was very, very appreciated. The peculiarity of this product was that, similarly to Enlightening Pen, the advertised pen features an internal lighting system. However, it internally is equipped with a transparent stem that you can see here, onto which you can apply a pre-printed film which might bring logos, messages, or images. This allows, of course, to achieve a very strong personalization of the product. You may imagine what will happen in the market after the launch of this pen. Quickly, the advertised pen erodes market shares of Enlightening Pen. Pens and Pens enact an aggressive advertising campaign, but it fails to protect its market position because the advertised pen is much more attractive for customers. So the investments in a new production facility that was decided now appears unjustifiable, and the shareholders complains for Mr. Penn decisions, which is, of course, a very bad situation for him. Then it turns to the country's top hyper firm, complaining about this absolutely unacceptable counterfeiting of its products by Ming Enterprises, and asked to immediately stop this competitor from eroding his market shares. Then they meet with Mr. Pence meet with his patent attorneys, IP counsels, and explores the available legal tools to react to Ming Enterprises competitions. First of all, the question is if the technology of the Enlightening pen is subject matter of any patent. So the question is, Mr. Pen, have you filed a patent application? Have you a patent granted on your technology? And Mr. Pen says no. Has Ming Enterprises infringed a trademark of Pens and Pens? No, because the name of the two pens are clearly different and they cannot in any way bring any confusion on the market. So a trademark infringement can be, of course, excluded. Does being implemented any unfair commercial stratagem to erode enlightening market shares? They asked to Mr. Pence, and the answer is no. Mr. Ming or Ming Enterprises just produced a different product with enhanced properties and marketed it. Okay. The reaction of Mr. Pence, of course, is not that fair, and he concludes that à la guerre comme à la guerre, he will produce the same pen or a similar pen like Ming Enterprises pen. Unfortunately, Wang Ming holds a patent which protects the technical features of advertising pen. This is a true patent. My story is fantastic, but the patent is a true patent. I will try to share it with you. Please confirm that you can see my eSpaceNet page.
Yes, we
Giulio.
can see it. Thank you.
Okay, thank you very much. This is the database of the European Patent Office, and you can find here the US patent application for an advertising light emitting pen, finding the name of Mr. Wang Ming. It was granted, and it relates to a pen which is exactly what we presented to be in as with reference to the product itself. You also can see here that there's a LED and the part, the transparent part, and every feature that characterize this pen. Coming back to our presentation, here we have the patent. In this case, we have the application publication, but the patent was actually granted. Of course, Mr. Pence decided not to give up and wanted to enact any action to counter this very strong position of Ming Enterprises, and consider that probably they should copy Ming pen, but at least a design around was necessary. So he thought to modify the snap-on mechanism just to make a different pen from that was the advertised pen, but keeping the stem with the applicable film, with pre-printed applicable film in his own product. Unfortunately, even this wasn't possible, because in the patent, several options of the snap-on or activation mechanism were encompassed. So the patent in the name of Ming Enterprises was actually well done. Well, let's say, of course, in the field of patent attorneys, a well done, well written, well prepared patent, which focuses actually on what is the core, the heart of the invention, and leaves possible optional features encompassed in the scope of protection of the patent itself. The result of the situation is almost obvious, and as well as obvious the moral of our story. Now, our story is that IP rights holder um, have have a clear advantage in properly using IP rights, which are the legal um, tools for enhancing their competitiveness. I presented the IP right in general, just summarizing how patents work, but of course we have several other tools to protect corresponding um, intellectual property, intellectual creations. For example, the design of a product. Um, Several of you, I think, know this lamp, which is a very well-known design lamp, which was protected not for its technical features, but for its appearance, so for its design. It's in the name of Artemide, which is an Italian company, and the inventor, the creator of this lamp is Mr. Kaluki. But we have also this lamp, by the way, is named from on the market Tolomeo. So if you want to buy this lamp, you have to ask Tolomeo lamp. Is there any legal tool to protect also this means for connecting the product to the producer of the product? Because Artemide, who invented not only the lamp from a design point of view, but invented also the name of the lamp, associating the name Tolomeo to this lamp, has had any means, any legal tool to protect this idea? Yes, they had the trademark. A trademark can be registered. Here we have Ptolemy name registered by the Artemide company. In this case, we have it was registered in 2010 and renewed until 2030. So we see that in this case, where we have a single product, a lamp, which was protected by using two, and in truth, if truth be told, three legal means. The first that you saw as the design registration. In this case, you see the United States design patent, but it's just about the name of the tool, patent in the United States, registered design in the European Union. But the legal mean is actually the same and in the same way enforceable. On the other hand, the same product is connected with another legal tool, which is the registered trademark. So one thing to keep in mind when you develop a new idea, whatever idea you can have developed, before sharing it with the market, consider if or what legal tool is available to protect the aspects of your idea, so that you can take a conscious and decision on what or which legal tool adopt to protect your idea, your intellectual creation in the best way according to your objectives as enterprises. One last example is a shape that was registered actually as a design, which became also a trademark. Here we see a bottle. I would like to have from you that are here, and you might reply by the chat, or Giulio may report just the answer. I would like to ask you, what do you see in this drawing? What is your first feeling?
So I invited the attendees to type in the chat or in the Q&A so we can see, but I don't know, maybe we can wait some seconds, then I can also give my
yeah, please.
my answer. Come on, I invite the attendees to not be shy and type in the Q&A or chat box what they see.
In the drawings, of course.
Okay.
What is the
Okay,
feeling?
there's a first the first reply is the design of a bottle, then a Coca-Cola bottle.
Yeah.
Which also was my my answer.
Yeah.
I see the original glass bottle
Yeah.
of the Coca-Cola.
Yeah. And actually, it was Coca-Cola company who filed this registration application. But here we see how a shape might become a trademark. So on one side, we have a legal tool, which is a registered trademark, which is suitable for protecting the design of your product, notwithstanding what technology is used inside, if any, of your product. But if during the use of your product, the shape of it acquires a distinctiveness on the market, it might become a trademark. The main difference is that design registration is limited in time. You might have it for 25 years at the most in Europe. Trademarks can be renewed 10 years per 10 years, as long as you want. So here we see that the possibility to use two different legal tools to protect your competitiveness, in this case, Coca-Cola company competitiveness, thanks to, well, on one side, the registered design when it was still valid. It's of course from 1937, so the time for the registered design is now lapsed. the design is now lapsed, of course, but not as a trademark. As long as we see a connection between this shape and the company that created this shape, we have legal tools that allows this company to contrast, to act against any other competitor who might try to use this distinctiveness to take advantage of the investments in the end, of the investments of Coca-Cola company. So here my presentation comes to an end, and I hope that, yeah, in just 2 minutes too long, but I'm available for any question you would
Yeah.
to submit.
Thank you, Michele, for the very nice presentation. I invite the attendees to use the Q&A box to post their questions. So maybe I can break the ice with one simple question, maybe from a person who is not absolutely an expert on IP rights. For instance, in the BIMAC project, we have launched the open call, so SMEs can benefit from the services that our open innovation testbeds provide. But at the root, they will come to us with an idea, with a concept that we'll try to develop. So what is the best pathway in the European Union context, legal framework? What is the best solution that a small company, a startup even, has to protect the innovation that they develop? Are there different tools or just a patent, or what's your opinion?
Thank you for your question. First of all, when startups comes to me and ask the same question, I take a step backward, and my consideration is, as a startup, what do you have? Have you buildings? Have you a lot of monies, resources? No, you have an idea.
Mm-hmm.
Probably a very nice idea, and something that could be striking in the market. So first of all, consider, and if a startup comes to an IP attorney, of course, is on the best, took the best way, the best first step to have at least a good knowledge of what are the legal tools. You named the patent. The patent is a legal tools which is aimed to protect technical solutions. So for each legal tools, you will have a specific application. For example, patents are for technical solutions. Registered design protects a statistical solution, which cannot be protected by patent. In the same way, registered design cannot protect technical solution. Trademark registration cannot protect neither the aesthetical solution nor the technical solution of the product, but is aimed at protecting this link that you are building with the market that will recognize that this product, which is identified by your trademark, comes from you and from nobody else. So if you, for example, go to a trade fair and you make monies to be visible and so on, all these monies are actually connected and protected by your control on your trademark, because the value which is associated to your product or service will be recognized on the market in the end by the name or logo that you will choose to make it distinctive. So a very important step, in my view, is being well aware of which are the legal tools, how they work. So first of all, get comfortable with these legal tools. We spoke about patents, designs, registered trademark, but we have also trade secrets, which are legal tools, the protection of trade secrets, legal tools that are very effective wherever your invention, your idea, for any reason, for example, cannot be patented because it's not something technical, is not something aesthetic, but might be something connected to a business method, for example.
Clear.
If you think to have discovered or find out a very effective business method, you have not access to these other tools for protection, but still you have the trade secret, and you shall be aware of what are the conditions, the legal requirements to accede the legal protection. And this is true for every legal tool. For example, inventions should be new, inventive, and industrially applicable to be patented. Designs should be new and distinctive on the market. In the same way, trademark should be new and distinctive to access the protection of the registration. And in the same way, trade secrets have, of course, to be secrets and to be kept secret, adopting specific act during their handling, let's say. First of all, non-disclosure agreement, for example.
Clear. And so we have two more questions.
Yeah.
One perhaps has partly has already received an answer during your this later part. It's how and when can we understand if we can protect a product, patent or design, and what costs are involved in protecting a product. So perhaps you can answer to this second part about the costs of protecting the innovation.
Yes, because how you can understand, you will need to ask a professional about that. This is the simplest way, and usually a professional gives you a consideration free of charge. So this will not be nothing terrible. Costs are very connected to the professional to which you will ask the consultancy, because usually cost depends on registration costs, registration fees, and counsel fees, which are much more high than the official fees. So the most part of the cost for having a good shaped patent filed or an effective a registered trademark or a registered design will be the cost of your attorney. But of course, nobody is compelled to be assisted by an attorney. All can be done by himself or herself, just for example, going through the internet and visiting the European Union Intellectual Property Office and the European Patent Office. You find a lot of informations, webinars, and a lot of tools that can help you. But take care that usually if a mistake is made handling intellectual property rights, there is no second chance. When a
Okay.
patent is filed and is published, there is no way to come back to come back to the past, and if something went wrong, to correct the
Okay.
situation.
Yeah. Yeah. Please conclude.
So I may provide you an average cost that I think that in Europe could be relatively common, which could be 3,000 euros, between 3,000 euros and 4,000 euros for filing a patent application. This,
Okay.
of course, consists in the large part in the cost of your attorney. And
Clear.
so I see also another question, which
Yeah.
is the minimum level of novelty to enhance patent protection
Correct.
as is the same in all Europe. In Europe, we have a very small option, which is the European patent. The European patent is tool that allows you to file a single application for 38 member states of the European Patent Convention, which is not the European Union. So you can file this single patent application for all the 38 states of the convention, and you have the possibility to go through this single patent procedure, and at the end of the procedure, you will be asked to validate your patent in the countries that are of interest for you among those 38 countries. Usually, for having a European patent, for going through the whole European patent procedures is usually takes between 2 and 4 or 6 years. So you have time to select what will be the geographical the proper geographical protection for your market. There's a news in this field because a unified patent system is going to start from 1st June 2023. So in this year, it means that at the end of the procedure of your European patent application, when you have hopefully granted your European patent, you will have the chance to register it to have a unitary effect of the European patent. This will allow you to have a single patent which will be valid in a plurality of states from the European Union. At this stage, 17 states, but they probably will become more and more the time going. Yes, it's the same in Europe, but sorry, I started from the second question. The first question is if the minimum level of novelty to have a patent protection granted is the same in Europe. Yes, it is. Of course, every country has, in the same way as we have all our culture, also juridical culture may differ among countries, but the principles are highly harmonized. So the requirements to have a patent granted are almost the very same in every state, European state, but also at a worldwide level. Just one thing, novelty is for sure the most uniform requirements, because novelty is the requirements for an invention to be not already known. So if you have any written source or any other source that discloses your invention is not new. But if your invention has something different, it is actually new. The question is if it implies also an inventive step. So it's not sufficient to have a new solution, but it is necessary to have a qualified new solution to accede the patent protection, as the same is for all the legal tools. In the end, the legal tools gives you a monopoly in the territory in the jurisdiction for which they are granted. So of course you understand that authorities that have to evaluate these requirements should be very, very sharp in their activity.
Okay, thank you very much, Michele, for the very clear answers. So there are no more questions. So, and also we are also exceeding our time today. So thank you very much again for your presentation, for
Thank you
replying
all.
to the questions. Thank you to the attendees who participated. The recording will be available soon on the YouTube channel of Biomac, and there will be new training sessions in the coming months. So stay tuned. Thanks again, Michele, and see you next time. Bye,
Have a
everybody.
nice day to all.